How are you?
Good, thank you, sir. Thank you. So I have had the pleasure of working with Alan for whoever is watching this for a long, long time. We have traveled together, we have held multiple seminars together, and so on and so forth. But for the people, our audience that don't know you, a little bit about what you particularly do and your law firm, that would be great.
Sure. So I've been a practicing lawyer for about almost 15 years. Not quite. I have been focusing on immigration law for the past 10 years. I started my own law firm about 9 years ago, and I only practice immigration law. And this is not a knockoff on any other lawyer who practices in different areas, but I just think that the immigration arena is so complex, it's so ever changing that, to be honest with you, it's sometimes difficult even for people like me to keep track of everything that's happening on a daily basis. And so I'm very, very proud of being the owner of a five-star law firm. And that is not really to brag, it's just to say that the reason we are a five-star law firm is because we go above and beyond for our clients. We make their cases our cases, their joys are our joys, their sorrows are our sorrows. And especially in this toxic atmosphere, I think it's important to have somebody in your corner that's fighting for you, and that's what we strive to do.
That's awesome. That's great. Yeah, absolutely. And I can vouch for that. I mean, Alan is an excellent immigration attorney who truly, truly cares. So I appreciate your time. Thank you. Today we're going to talk about change of status. As obviously you know, and we have had multiple discussions, international students with student visa have been a very hot topic and subject matter recently, and obviously in the last days. So a lot of students right now that are here in the United States, they are obviously evaluating their options in order to change their status from from student visa that they are in on into something else, right? Another visa. And we always talk about that you can change your status from student visa to another non-immigrant visa, meaning as like a work visa, like an H-1B, or you can change it to another immigrant visas, which are the green cards. So can you a little bit tell me or tell the audience about change of status? Like, what is a change of status in general, and then what happens, and then we can get into specifics.
Sure. So let's start from the beginning. So when we talk about non-immigrant visas, we're talking about visas that do not lead to a green card, also referred to as legal permanent residence in the United States.
Mhm.
And so when we talk about immigrant visas, on the other hand, we are talking about visas that actually do give you a pathway to one day holding a green card and becoming a permanent resident of the United States. When you are an F1 student in the United States, you are in possession of a non-immigrant visa. That visa comes with a lot of restrictions. Oftentimes, it takes a company petitioning for you or an immediate relative petitioning for you in order to pave the path to a green card.
And by
And
petitioning,
so,
so I didn't mean to interrupt you. By petitioning, you mean request, like someone has the
right,
immigration request, right, to apply for your green card.
exactly, exactly. And for our audience, Ashkan and I were talking earlier, and there's just so much information out there that books and books and books have been written about all sorts of different categories. So I think it would be a disservice to the audience to um, talk about every single one of them superficially, meaning just a little bit, giving a summary. So we were thinking of going deeper into one particular way
Mm-hmm.
of changing one's status. And then hopefully, if Ashkan will invite me back, we can in the future address some of the other changes of status But today perhaps we can focus on one particular topic, and so I'll let you lead on that.
Yeah, absolutely. That's great because, and then so everybody can understand, you can change your status from one, as Alan mentioned, from one immigrant and from one visa to the another one, whether if it's a non-immigrant visa or it's an immigrant visa. But there are so many different categories. As I mentioned earlier, there could be a work visa, or it could be a petition or a request from like a green card, meaning as like your employer from a work green card, or you can get married. Now, we actually went through most of the questions that we got, right? And so most of the questions today that we got, majority of them are about marriage-based change of status. So how do you get, when you get married, or when you intend to get married to a U.S. citizen or U.S. green card holder, and you're currently here on a student visa, what does that process look like to change your status? And then we can dive into it. I think the second thing is employment, which if I would again appreciate your time. Perhaps next session we can talk about changing status from student visa to work visas or work green cards. But today, let's focus on marriage, and then if you want to change your status from student visa to a marriage green card.
Sure. So the agency that you will be dealing with is the U.S. Citizenship and Immigration Services, which is under the Department of Homeland Security. If you are a student visa holder and you happen to be married to an American citizen, you would file a one-step petition with USCIS. Now, why do we call it a one-step? Because in one step, you are going to be filing a whole slew of forms together. And by the time we are done putting the forms together along with the supporting documents, our packets are anywhere between 250 to 350 pages. Now, I have a lot to say, so Ashkan, please feel free to interject, cut me off.
I will.
No hard feelings. So just interject, because there's a lot of information that I need to transfer from my brain to the audience, and so I tend to sometimes talk a lot. So I apologize in advance.
No, this is good. Go ahead, please.
So the forms, generally speaking, that you will be filing have to go to USCIS. They include the Form I-130 to prove that the relationship is bona fide, the I-485, which is the application for permanent residence, the I-765 to obtain permission to work in the United States, the I-131, which is the travel/advanced parole document, the I-693, which is the medical examination report, which, by the way, does not have to be filed at the time of the one-step petition. You can actually get it done and take it with you to the interview. The I-864 to show that your petitioner has the financial means to support you. And until recently, the I-944 self-sufficiency application, where you need to show things like, what's your credit score like? Have you ever filed for bankruptcy? How well do you speak English? All sorts of information about your background, scholastically, professionally.
So those matter.
All those things matter. But as of just a few days ago, a federal judge put a stop on the implementation of the public charge rule throughout the pendency of the COVID-19 pandemic. So as of today, which is August 7th, the I-944 does not need to be included in your packet.
Okay.
So that.
So let me ask you a question. Let me take a step back. I'm a student on a student visa right now in the United States, right? Let's say just for the sake of example, last year in January, I have entered to start my university. And so I've been here for 8 months now. Can I, if I want to get married today, can I file an application? Is there a certain period of time that I need to wait in order to change my status?
So that's a good question, but and I get that question all the time, but it's a question that, and this is no offense to you, misses the point.
Yes.
Because it's not a matter of how long do I wait to file. It's a matter of whether my relationship is real, bona fide, and what evidence do I have to prove to the government that it is in fact bona fide. So for example, you could have dated an individual for 2 months, gotten married, and she is now at the cusp of filing for you. On the other hand, you could have dated somebody for 8 years, and finally you decide to tie the knot, and she petitions for you. And so I think the focus for our listeners should be, what evidence do I have to prove that the relationship is real? Why? Because unfortunately, over the years, a lot of people have taken advantage of the system. And so because of that, things have gotten harder for honest, good people such as our listeners or viewers today. And it's just a reality. It just means that you have to now work a little bit harder to prove that your relationship is bona fide.
So there is
and
no
I'm
certain,
sure we'll get into that.
yeah, so there is no, so, okay, so fantastic point. So there is no time limit that you would put on it, right? It's just based on the fact that your relationship is real and you are getting married for real, because obviously doing this in order to gain immigration benefits, it's illegal and you should not do it. So the purpose is that, or the idea is that to prove that the relationship and the marriage is real, and it doesn't matter how long it has been.
Exactly. But I think you're asking, I think you're alluding to a very, very important concept, which is that what if you are a student visa holder and your spouse happens to be a green card holder? What then? She's not, or he's not an American citizen yet.
Yeah.
She holds a green card. So what do I do then? And this gets a little bit complicated, but at the same time, it's not complicated. So what happens is that you as a student visa holder have to maintain your status throughout the pendency of the application, because you do not enjoy a marriage with a U.S. citizen. You are actually in a relationship and a marriage with a green card holder. So under the F2A category, number one, a visa has to be available to you, not only when you are filing for green card, but throughout the pendency and on the day of your interview. That is when the government can actually extend a green card to you.
Got it.
And we'll get into that in a little bit, because it gets a little bit dicey, a little bit complicated.
Absolutely. And it's, you know, some of this stuff is too detailed for a video. So actually, this is a good segue. So I want to mention to our, you know, audience, whoever is, obviously, if your language is Farsi, or you prefer to have this in Farsi to the explanation, you're more than welcome to contact us or book a consultation with us, so we can have Alan and I both explain the process to you in Farsi. Also, we'll be more than happy to send you some documents for you, or again, Turkish or Portuguese. We can definitely help you out in that aspect. But so I have a question for you. One of the questions that actually we got, that is one of the most common ones. Let's say all that has happened, and I'm ready to file my change of status today. How long is it going to take before I get my green card, providing that I have married a U.S. citizen?
So I'm going to answer your question based on pre-COVID-19 conditions.
So before COVID-19 and the restrictions that was caused by COVID-19.
Exactly.
Okay.
Because the virus has created some chaos, not only nationally, but internationally. And as a matter of course, it has affected how certain cases are being processed.
Sure.
So what happens is, let's say you get married to a U.S. citizen and he or she petitions for you today. We have everything ready. We file it with USCIS. Approximately 2 weeks later, you get a receipt notice from the government saying, thank you very much. We received your application.
Okay.
About the same time, you get a notice to go get your biometrics done. It's a fancy word for fingerprinting.
Okay.
About 5 to 7 months after filing is when you would get your combo EAD, Employment Authorization Document, and Advanced Parole Document. It's going to be one card that's going to serve two purposes, work and travel.
Okay. How long does that take, you said, typically?
5 to 7 months.
Okay.
About 9 months after filing, you should expect to get an interview notice.
Mm-hmm.
And about a month or so after your interview is when you should expect your green card.
Okay.
Your legal permanent resident card.
Mm-hmm.
Now, as I said, the timelines that I just mentioned are based on pre-COVID-19 conditions. Because of the mayhem that the virus has caused, it is logical to presume that there will be some delays. We unfortunately don't know how long those delays will be. We presume it might be a month, 3 months, 5 months, or we may all be surprised and realize that there have been no changes.
Yeah, same timeline.
So a little bit of unknown uncertainty in that.
Okay, so great, thank you for that. So the third question now, most common questions that I had was, once in the process that you explained, and after, let's say, pre-COVID-19, 5 to 7 months, I would get my obviously card, which I can work. I have a work authorization, and I can travel. Do you, I don't want to say suggest, but do you recommend that I should remain in the U.S., or is it okay if I actually travel, since I do have the authorization to travel outside of the United States, or should I remain in the U.S. until I actually get my green card?
I always look at the advanced parole document as an opportunity to travel if an emergency presents itself.
Mm-hmm.
So in other words, if your intention is to travel because you'd like to go on your honeymoon, or that you'd like to visit your parents, those are all good reasons. But in my humble opinion, they are not good enough reasons to travel just yet.
Mm-hmm.
Why do I say that? I say that because the advanced parole document does allow you to re-enter, but remember, it's discretionary. Your admission back into the United States is at the behest of, at the discretion of, the officer who is inspecting you. So if there are additional inadmissibility issues that either the applicant or the lawyer is not aware of, and all of a sudden it comes to fore, it becomes evident, then the applicant may be prevented from entering the United States. So for that reason, I tell my clients, travel if you must. As a matter of fact, just 3 weeks ago, one of my clients whose mother was recently diagnosed with stage 4 cancer came to me and said, I appreciate your counsel, but family comes first. I understand that there's a 5% or so risk that I may not be able to return, and I will have to consular process through the National Visa Center and whatnot. I understand that, but my mother means the world to me. I will not risk not seeing her before she passes. And so my point is, lawyers will say things. Why? Because lawyers want to protect their clients.
Mm-hmm.
But sometimes life is way, way, way more important than immigration. Way, way, way more important than anything else.
You're right.
So for that reason, sometimes my clients don't follow my advice, and that's perfectly okay, because it's the right decision for them.
Okay, great. Okay, thank you for that. So one of the recent questions that we just added, I'm going to read it actually. So the question is that, what if my spouse that is filing for me to get my green card, again, for some of the people who just joined us, we're talking about change of status. If you are a student visa, to changing your status to get your green card through marriage. So I'm on a student visa, and then my spouse is filing for me to get my green card. What if my spouse is not employed right now? What do I need to provide in order to show financial, basically, statements or
Sure.
affidavit?
So employment is one way to financially sponsor a beneficiary. Assets are another way. So for example, if the petitioner has real estate holdings, stocks, bonds, savings, what have you, basically assets that can be converted into cash easily within 12 months, considered to be liquid assets,
Okay.
then that we can use that based on a very specific formula to make up the difference. But USCIS still wants to see that the ability to sponsor will continue. So even if I have enough assets, enough bonds, stocks, etc., I always encourage clients to get a joint sponsor.
That was my question.
That joint sponsor can be a family member, a friend who can provide us with their tax returns for the last 3 years. And we essentially use that person to assert to the government that this person is not likely to become a public charge, meaning a financial burden upon the United States.
Yeah.
And so important to remember that the petitioner has to be a green card holder. I'm sorry, the joint sponsor has to either be a green card holder or a U.S. citizen.
Yeah. Okay. Fantastic. Last question that I have for you is, how do I prove, because one of the requirements to prove, obviously, that you are getting married or you're filing for your marriage is to prove the relationship and the marriage, as you said, is real. How does one prove that the relationship is real?
So that's the $64,000 question. But the bottom line is every relationship is different. The one commonality that they have is that they share one thing in common, and that's love. How do you go about proving love? In the eyes of USCIS, there are two ways that one can go above and beyond in proving that. Number one, cohabitation, living together.
Okay.
Number two, commingling of funds, meaning sharing money.
So same bank accounts or joint bank accounts.
Right. Those are the two most important aspects of the proofs that you want to submit.
Okay.
Now, in addition to that, there are countless other ways. So, for example, joint health insurance, life insurance, auto insurance, cell phone bills, gym membership, etc., etc., etc. And there is no right or wrong answer because people merge their lives together in different ways. But it always becomes tricky when a couple does not live together. For example, not too long ago, we had a client who was a devout Muslim. They had gotten married in City Hall, but they had not done their nikah, which is in the Islamic faith, their traditional Islamic wedding.
Yeah.
So what happened was we filed without proof of them living together, but providing affidavits, statements from both of the individuals as well as family and friends saying, because of our religious traditions, we are not allowed to live together until a certain ceremony has been completed. And so My point is, I am saying one thing, but sometimes you cannot get proof of that one thing.
Yeah.
And so you have to find other ways to go about proving the bona fide nature of your relationship.
Got it. Okay. So to sum it up, some of the best things that can help you is if you live together, providing support or providing documents that you live together, health insurance you mentioned, and financial bank accounts, joint credit cards, joint bank accounts that you have together, that you share financial.
Right. And as a last point, I'll say that nobody knows their lives better than the couple.
Mm-hmm.
And so these are just examples. Sometimes clients come to me and say, hey, we have all these cards that we received, greeting cards, receipts for gifts for one another, and we have tons of photos. And I say, those are all amazing.
Mm-hmm.
As a matter of fact, one USCIS officer in one interview last year did not spend a single second looking at any of the documents that I had provided. She went straight to the photos and she looked at me. She said, you know what? Pictures can never, ever lie. Photos never lie, but documents can. So she approved the case within 5 minutes. It was I'm not even joking. The whole interview lasted about 11 minutes. 5 minutes of which she spent looking through the photos. So it was a very, very pleasant interview, and the individual has a conditional green card as we speak. So it just depends on what evidence you have, how you go about getting it. And if you are lacking on evidence, then I would say go to your friends, go to your family, get them to write statements so that they can attest to the bona fide nature of your relationship.
Yeah, that's great. One thing that you just mentioned, and it was not in the questions, which I think is important to address, is the conditional green card. So you mentioned conditional green card. So tell us a little bit about conditional green card and how long that is for, and then what happens after the conditional green card is basically it's expired, or what is the purpose of the conditional green card, and then how long that is for.
If at the time that USCIS is ready to issue a green card to you, a legal permanent resident card, if at that time your marriage to your spouse is longer than 2 years,
mm-hmm.
you will get the 10-year green card.
Okay.
If your marriage is at that time less than 2 years, USCIS is going to give you a 2-year green card known as the conditional green card, because USCIS wants to see you again.
Mm-hmm.
USCIS wants you to come back essentially in a couple of years and prove to the agency that you're still together, that you still love each other, that everything is fine, and provide additional proofs. At that point, you can change your 2-year green card into a 10-year green card.
Perfect. That's awesome. Well, thank you. I really appreciate your time. I think this is great. There's a lot of uncertainty. There's a lot of, unfortunately, a lot of misinformation out there, which I think is important for us or even anybody that does practice in these fields to, have these sort of informational sessions, so then people can watch, learn, and get their questions answered. So I appreciate your time.
You're very, very welcome. And I'll say just one word before we part ways. One of the most frequently asked questions I get is, Alan, do I need an attorney?
Mm-hmm.
And without flinching, unequivocally, 100%, looking them straight in the eyes, I say, no,
mm-hmm.
you do not need an attorney.
Mm-hmm.
Why do I say that? I have been blessed with amazing clients. Most of them are young. Some of them are superbly educated. They are smart. They can read instructions, and they can fill out the forms. It doesn't take a genius to complete the forms. However, being the son of immigrants myself,
mm-hmm.
being a first-generation immigrant myself, having traveled halfway around the world 30 years ago to make it to the United States, I can tell you that I would not be where I am today had it not been for very special, helpful people along the way. And so I would say, think of the immigration process as an investment in your future, because a little mishap, a little misstep here, a little misstep there can cause delays, can, God forbid, change the outcome of a case. So the question is not, do I need an attorney? Because you do not need an attorney. You need food, you need water, you need air, you need certain things like that. But I would say the better question is, should I work with an attorney, or would you, if you were in my shoes, would you work with a lawyer? And in that case, the answer becomes yes, because there's too much at stake. The rules and regulations are ever changing. And even if the viewers don't call you, don't call me, and that's perfectly okay, but I implore them, I implore the audience to work with a trusted attorney who will take your hand and be with you every step of the way until the very end. And I would say there are amazing attorneys out there who truly care about you. And please don't be discouraged by the toxic rhetoric that is coming out of Washington, D.C. Things will get better. I'm an eternal optimist, and I really hope that our paths will cross, and that you will give us an opportunity to help you along the way.
That sounds great, absolutely. And one thing to add to it, one thing that you and I have always in common is that how much we're passionate about, helping people, and when it comes to immigration, because we have seen the challenges, both you and I, we have seen it, not only ourselves, but actually our family members have experienced this. So, I know that you're the same way. We're all very passionate about this. So it's not only, we don't look at it as only, both you and I know we're the same way. We don't look at it in the way of just, work or getting clients or having a company or having a law firm. We actually look at it in terms of helping people, because that is a true passion for both of us. And I know that for sure.
I appreciate that, and I see that in you. And this is not just me complimenting you because you're in front, and on the screen and whatnot. But you're absolutely right. This is not work. This is in my DNA. It's in your DNA.
Yeah.
And as a matter of fact, there's a famous saying that says, "You often meet your destiny on the road you take to avoid it." And so I have avoided immigration law the better part of my life, and yet here I am in the middle of immigration law, trying to help people cross over into certainty, into optimism, because the landscape is very, very daunting right now. The landscape is very, very scary right now. But this is the United States of America. Rules matter, laws matter, and I am hopeful that rationality will win over fear-mongering, that optimism will eventually prevail. And these are not just big words. These are coming from the bottom of my heart. I see the pain and anguish in the eyes of my clients, and I continually assure them that as long as I am by their side, I will not let anything happen to them. And that is the kind of advocacy that unfortunately is warranted in these difficult times.
It's true. Well, thank you for that. I appreciate it. Once again, thanks for your time. And then we'll schedule another session of change of status for international students to, let's say, I think the second topic, that the most common topic that we got was employment. So next session will be about employment, if you're okay with that.
Absolutely. And I want to thank you very much, because I finally put on a suit, and I was very, very happy that all of the junk food that I ate didn't make this suit useless. So yeah. I think I look okay. So
you look great.
All right.
Thanks.
Thanks, guys.
I appreciate it. Thank you.